If you are an immigrant married to a U.S. citizen or a green card holder, you may be trapped in a relationship where the abuse is invisible. You have no bruises, no police reports, but the pain is real and you feel like you are losing your mind. The crucial truth is this: you do not have to be physically abused to qualify for a life-saving immigration protection under the Violence Against Women Act, or VAWA. VAWA is gender neutral. Men, women, and non-binary individuals can apply for VAWA. Today, I will be breaking down how emotional abuse, also called psychological or mental abuse, is legally recognized as extreme cruelty, a qualifying form of abuse that can lead to permanent lawful status in the United States. I am U.S. immigration attorney Lillian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. In the context of VAWA, U.S. immigration law defines qualifying abuse under two categories: battery or extreme cruelty. The legal definition of abuse is very broad and flexible and does not require physical injury in order for USCIS to see that there was abuse in the relationship and to qualify for VAWA. USCIS regulations specify that extreme cruelty includes acts that result or threaten to result in physical or mental injury. Most importantly, USCIS determines extreme cruelty by looking at the abuser's intent or pattern of behavior and control over the self-petitioner over time. Emotional abuse is often repeated and subtle, making the victim question their own reality and sanity. The core goal of the abuser is leveraging the victim's vulnerable immigration status as a weapon of control. Psychological or emotional abuse can take many different forms, so when you are going through it, you may not know that you are actually going through it. So it may seem like just normal couple arguing. However, when you look at the pattern of behavior, you may see that there's more to it than that. A form that psychological or emotional abuse can take is verbal or psychological degradation. Basically, this includes constant criticism, verbal attacks such as yelling, screaming, insulting, or mistreating you verbally. Abusers may belittle or embarrass you in public, call you racist names, or use terms like trash, low life, talk down on your culture. For example, saying that your food smells when you cook your traditional cuisines. Things like that can cause emotional and psychological harm. And these actions are designed to destroy your confidence through insults and manipulation. Another form that psychological or emotional abuse can take is isolation and forced detention. Abusers may isolate or cut you off from people in your life or your job or things in the community that give you access to other people, access to information. This involves controlling where you go, what you do, and who you can see. They can prohibit you from using your phone or the car, prevent you from going to work, prevent you from learning English, or stop you from contacting family and friends. Again, they may frame this as, I want to spend so much time with you. If you're talking to all these other people, we don't get that time together. And slowly, you realize your whole life revolves around this one person. You cannot drive. You cannot go anywhere without them. You cannot work. You cannot do anything without their consent. Eventually, that becomes the cycle. In severe cases, this imposed isolation can amount to forced detention, where they basically don't want you leaving the house. You feel that if you step outside, this is going to cause your spouse to lose their mind, to physically attack you, to verbally attack you, that you basically shut everything out and you follow whatever guidelines they have given you. You may think, I am being, a good spouse, but by isolating you, they get to control what you do, who you see, and what information you are able to get. This may not be your situation as you're watching this, but you may have a family member, a friend that you have noticed that they have slowly been isolating themselves once they got into a relationship. Right? You may be that person that can help bridge that gap for that friend or that family member. So when you're watching this video, if this does not apply to you, I still want you to listen. I still want you to pay attention, because there may be someone in your life going through this, and you can be that catalyst to change their lives by letting them know that there's a way forward without having to remain in that abusive relationship. Another form that psychological and emotional abuse take is immigration control and threats. This is a classic pattern of abuse. The abuser may threaten to deport the person or turn you over to immigration authorities. They often refuse to file papers that will help legalize your status in the US, or threaten to withdraw an application that they already have filed for you, telling you that you are only in the US because of them and that they will always win because they are a US citizen. If this is you, please pay attention. Just because you are married to a US citizen does not mean that you get to live through abuse. Okay? VAWA was specifically created for spouses of US citizens and permanent residents to be able to get out from that abusive relationship without having to rely on that spouse that's abusing them to gain status. So that abuse that your spouse is putting you through is actually a pathway for you to not only get legal status in the US, but to also eventually get your citizenship in the US. And just so I can make it even more clear, marriage to a US citizen does not mean you get to be abused or they get to abuse you. It means that you are supposed to have a loving, long-term relationship with your spouse. It does not mean that you get to be treated horribly and you get to be abused throughout your relationship. In my last video, I talked about financial or economic abuse. In this video, we're kind of looking at it in a different perspective. It can also come under the emotional and psychological abuse, because by limiting your access to your finances, limiting your access to employment, your spouse is basically continuing to manipulate and control your life. Refusing to give you access to money, refusing to give you access to a phone, so therefore you are not able to call family and friends, you are not able to get information. Those are things that you may see as, oh, it's financial, they're just not giving me the money to do this. But that financial abuse also plays into the psychological abuse, because it is all connected, right? I talked about that in my last video. All these forms of abuse is connected, and they work together to create this system of control of the abuse. I know I'm talking about these forms of abuse in different videos, and it may seem like they're all separated, but they are not, right? They all work together to create that manipulative control that the abuser is seeking. So now that we know what psychological or mental abuse is, let's talk about how you can actually go about proving it. You do not need bruises or hospital records to qualify for VAWA. Okay, you do need to show that this ongoing pattern of abuse led to mental injury. So there has to be some form of injury that happened to you because of the abuse, and that injury can be mental. It does not have to be physical. The severe mental health impact of the emotional abuse that you have suffered is crucial evidence in your case. Survivors often develop things like depression, anxiety, panic attacks, PTSD, and those things are severe mental health conditions that are created because of that emotional abuse that they suffered in the relationship. Unlike physical abuse, emotional abuse is a little harder to prove, and sometimes it's a little harder to get your mind around how to actually document it. When you are trying to gather evidence, you need to focus on gathering concrete evidence that supports your story. So your mental health record. So if you have had evaluations from a therapist or a forensic psychologist, counseling notes, or diagnosis of trauma, we want to see those records. One thing I always do with my clients is not only suggest that they do a psychological evaluation for their VAWA case, but that they also get an ongoing therapist to help them work through the trauma and help them actually move forward in their lives and beyond that trauma that they have experienced. Another form of evidence is personal documentation. If you write in a journal, if you have written accounts of the specific abuses that you have suffered, the specific incidences where things happen, we want to see that. So text messages between you and your spouse where they are threatening you, where they are, being remorseful for the last time that they did something to you, emails, voicemails, voice memos. I get so many voice memos now because it has become a normal part of our society. We send voice memos over text. So one thing that I would say is, as much as you want to delete those things, please don't. Forward it to a family member, forward it to a friend that you trust, so that when you are ready to take those steps towards VAWA, you have that evidence. You don't have to keep it on your phone, but make sure that you still have access to it. Because I have had people delete everything. They're like, I don't want anything to do with this person anymore. I'm going to burn everything, throw everything out. But part of the things you threw out, part of the things you burned, are the evidence you need to prove your VAWA case. So before you do any of that, make sure that you print it out, save it somehow, where you're not going to be seeing it on a daily basis, but that you can have access to it when it is necessary. One thing I tell my clients, instead of doing all of that, right, when someone meets with me, I'm telling you, send me everything. You don't have to keep it. Right? You don't have to keep it. You can send it to us. We will keep it for you and make sure we put it in your VAWA application, but you do not have to hold on to those things that cause you harm. Another piece of evidence that can be helpful is affidavits, sworn statements from family, friends, social workers, basically anyone who has witnessed the abuse or noticed changes in your behavior or mental state. This is really important because if family members, friends have actually witnessed you being abused, they can be great supporting evidence of your statement that there has been abuse in your relationship. If there has been social workers involved in your situation and they can attest to the fact that there was abuse in the relationship, that is helpful. Now, when I say affidavits, I say sworn statements. That means they are basically saying everything in this statement is true and accurate and is subject to the penalties of perjury. Meaning, if I lie in this statement, I can be held legally accountable for my lies. So that's why sworn statements are so important in these cases, because someone is basically saying everything I'm saying is true, and if it's not true, please feel free to prosecute me. Right? So that's why sworn statements can be helpful, but make sure not only does it say subject to penalties of perjury, you are also having it notarized. The importance of having these affidavits notarized is that it proves to USCIS that the person that wrote it is actually the person that wrote it, because they have to go to a notary with an ID. The notary confirms that it's them, confirms that they understand what is in the document, and then signs off on it. So getting it notarized is super, super, super important. So the last crucial piece of evidence you want to include is your own sworn statement, right? Your statement is your detailed and chronological account of the abuse that is considered primary evidence. So your statement is actually considered primary evidence of your abuse. USCIS is going to look at everything you give them, and they are going to consider any relevant evidence. Okay, so whatever you give them, they're going to look through it, see if it actually gives them the information they're looking for. Your statement is top on that list of things that they would consider. So your declaration is very, very important. Like I said, it needs to be a sworn statement. It needs to be detailed. Okay, I don't want you writing your statement saying, my spouse abused me. It was a bad abuse. I don't want to remain in this relationship anymore. Okay, that does not give the officer any details of how your spouse abused you, why they did it, when they did it, how many times they did it. Was they at home? Was they while you were with family and friends? What actually happened to you? That's what your declaration is all about. What happened to you, when, where, how? Okay, how many times? How did they abuse you? What did they say specifically? Those are the things that needs to be in your sworn statement. And like I said, if you can get as much detail as possible and actually do it in chronological order, that's great, because it gives an officer a full picture of, oh, this is when the abuse started. This is when we got into this relationship. This is when the abuse started. This is the forms of abuse that I suffered. These are the different incidents that happened to me. And then, ooh, the best part, if you can connect each of those incidents to a text message, a voice memo, right? All those things, even better. You don't have to. If you don't have those pieces of evidence, that is perfectly fine. But if you do and you can connect all those things, even better. I know I have mentioned voicemails, voice memos, and you're thinking, do I like burn a CD, put it on a flash drive? No. No. So when it comes to voice memos and voicemails, what we want to do and what USCIS requires of you is that you get that voicemail, voice memo transcribed, meaning written out what the person said word for word. That's what they're looking for. They do not want the actual voice memo, right? Because if you send a flash drive, the US government will not allow them to actually plug it into a device at USCIS to listen to the voice memo, because, you know, security threats. Okay, they don't want someone to send something that is corrupted and then they put it into the USCIS system and corrupts the system. So they do not accept any form of media, but if you can get it transcribed, that is the way to get it into evidence. One thing I hear all the time when people schedule a consultation with me is that I don't think this is going to meet the requirements because, you know, the abuse wasn't bad enough, or that USCIS wouldn't believe them because their abuses seem normal on the outside. But remember, USCIS understands the dynamics of domestic violence. Like this is a specific unit in USCIS that handles VAWA cases. So it's not just any old officer. They see this on a daily basis. So they understand the dynamics of domestic violence, and they understand why certain things may look great on the outside. However, what you're dealing with in your relationship is actually torture. It's actually horrible. Okay, so remember, do not self-diagnose, because remember, under VAWA standards, USCIS must consider any credible evidence relevant to your petition. Okay, any relevant evidence. I want to repeat that. USCIS must consider any credible evidence. Under the VAWA standards, USCIS must consider any credible evidence relevant to your petition. Your well-documented specific story backed with mental health evidence and affidavits can be enough. If your partner used emotional or psychological tactics to control, intimidate, or isolate you, and those actions hurt your mental health, you deserve legal protection. You deserve a path to getting your green card, to eventually getting permanent residency, getting U.S. citizenship. You do not have to endure the abuse in order to get your permanent residency. So important. You can leave that relationship and be able to get the permanent residency and avoid further abuses. And in every VAWA video, I will always say this, and I hope it is clear by now that VAWA petitions are confidential. VAWA petitions are confidential. USCIS is not allowed to ask your spouse about your VAWA petition. They are not allowed to notify your spouse about your VAWA petition because that is against the law. Okay, the law is set up to protect VAWA applicants that are victims of abuse. So USCIS is legally obligated to keep your information confidential and not share that information with your spouse. And that is also why when you are filing a VAWA petition, it gives you the option to have a safe mailing address. So where you live, if you're still living with your abuser, you can choose to not have any USCIS mail related to your VAWA petition come to that address. You can choose a safe mailing address for those mail from USCIS to go to. If you are watching this and this is resonating with you, either because you yourself are going through this abuse or a family member, a friend is going through this and they are staying in it for their immigration benefits, they feel that if they leave, they will lose everything, just know this is an option, and if you want to explore that option further, please feel free to schedule a free strategy session with me. You can do that by going to my website, lilylegal.com, click on contact us, and you can select a date and time that works best for you for us to talk about your immigration options, if you qualify for VAWA, what type of evidence you would need, and the next steps that you can take to not only secure your VAWA petition, your green card, but make sure that you are taking steps to protect yourself as you go through this petition.